Good morning, our distinguished guests, our panelists, our colleagues, and all the participants. On behalf of Olisa Gbakoba Legal OAL, it gives me great pleasure to warmly welcome you all to today's webinar on ADR and the energy transition, emerging trends in mining and renewable disputes. We at OAL, we have always been deeply committed to promoting innovative, practical, and sustainable approaches to dispute resolution. This webinar forms part of our continuous efforts to foster dialogue, share insights, and strengthen the use of alternative dispute resolution ADR as a vital tool in addressing complex commercial and environmental issues. As we all know, the energy transition is driven by climate change imperative and technological innovation, an evolving regulatory framework which has led to significant investment and activities in mining, renewable energy projects all over the world. This transition, however, also brings with it complex commercial relationship, regulatory uncertainties, and new types of disputes in our world that also require innovative and efficient, reliable mechanism for resolution. This is where alternative dispute resolution plays a pivotal role. We have mediation, we have arbitration, and all other ADR mechanisms, which offers parties in the energy and mining sectors the flexibility, expertise, and neutrality needed to resolve disputes efficiently while preserving commercial relationships and ensuring project continuity. In today's webinar, which is designed to explore many issues, we are going to look at the emerging trends and patterns of disputes arising from energy transition. We're also going to look at ADR in adapting to meet the demands of these evolving sectors. We'll finally look at the practical insights on how stakeholders can better structure the agreement and dispute resolution strategies in mining and renewable energy projects. We are privileged to have with us a panel of renowned experts and practitioners who will share their perspective, their practical experiences, and recommendations. I am confident that this contribution will enrich our understanding and stimulate thoughtful discussion in this webinar. I encourage everyone to actively participate, share your question, insight, and experiences so that this section becomes as interactive and impactful as possible. The moderator is going to read out the profile and CV of all the panelists. So I want to once again say thank you for joining us, and I wish us all a fruitful and engaging webinar. Thank you.
Distinguished listeners, guests, colleagues, participants, ladies and gentlemen, I want to equally extend a warm hand of regard to each and every one of you that have joined today's webinar. I and my colleague, Devia Agbakuba, will be moderating today's panel sections. Just before we proceed, I would just like to quickly give a brief overview of the Alternative Dispute Resolution Practice Group of Olisa Gbakoba Legal. As an alternative dispute resolution and arbitration law firm in Nigeria, we recognize that not every dispute should end up in court. Our team therefore prioritizes strategic dispute management using arbitration, mediation, conciliation, negotiation, and hybrid processes to deliver outcomes that protect client interests while preserving relationship and business community. OL ADRO team is led by citizen practitioners, accredited arbitrators, and mediators, including our very own senior advocate of Nigeria and the person of Dr. Olisa Lega. We have several Chartered Institute of Arbitrators, UK and Nigeria fellows. We have equally fellows of the Nigeria Institute of Chartered Arbitrators, NICAB. We are equally members of ICC Arbitration Committee and several other committees where we combine deep sector knowledge with procedural expertise. Now, our practice spans diverse sectors, which include the maritime, energy, construction, finance, intellectual property, employment, and public sector disputes, with a growing portfolio in international arbitration and multi-jurisdictional settlement matters. We also have actively contributed to the development of ADR policies and reforms in Nigeria, and we equally participated in the drafting and advocacy around the legal framework, such as the Nigerian National Arbitration Policy that was released. And we equally do some advocacy work around the Arbitration and Mediation Act that's currently equally in force. Our goal at OAL is to offer clients speedy, confidential, and cost-effective alternative to litigation. We anchor on fairness, professionalism, and global practices in dispute resolution. Once again, I equally want to thank each and every one of you for being in today's webinar. I will equally just proceed without taking much of your time to just do a brief overview with respect to the panelists that we have and equally give the panel format for today. First, we have Professor Olushola Olujobi, a professor of law at Afe Babalola University, Ado Ekiti, and is widely recognized for his scholarly contributions to corporate governance, energy law, and dispute resolution. He's a prolific author and a respected thought leader in the Nigeria Legal Academy. A brief of the profile will be projected by the technical team, while I just give an abbreviation with respect to his profile. And it's equally representing Professor Damilola Olawi, SAN, that is Senior Advocate of Nigeria. Also, we have with us Dr. Erima Orie, a doctor of environmental arbitration, whose research and professional work bridge the gap between environmental law and ADRO mechanisms. Now, Dr. Oria's expertise in specialized arbitrations makes our perspective vital to today's conversation. Our detailed profile will equally be projected by the IT team, so we all can just see. And finally, we'll be having Oruku Luke Agada. Is a seasoned lawyer, notary public, and chartered arbitrator. Mr. Agada, practical experience in commercial and institutional arbitration, both domestic and international arbitration, we had valuable insight into the evolving landscape of ADR practice and equally to this discussion as it relates to the topic that we'll be discussing today. We are truly honored to have such an accomplished panel with us today who will talk to this topic and give their perspective. The format of today's panel section, I'll just give a brief rundown with respect to it. There will be a brief presentation by Professor Olushola Olujobi. After the presentation, we'll proceed to the full panel discussion that will be moderated by Beverly, and that will run from about 12:15 to 12:30. During that segment, Beverly will engage our panelists in interactive conversation, exploring key terms in ADR ranging from practical challenges and policies developments to international best practices. Following the discussion, we open the floor for Q&A section from 12:30 to about 12:50 p.m., where participants can direct their questions to the panelists. The events will thereafter conclude with a closing remark, and after which we try as much as possible to ensure that from today's discussion, we are able to bring out some key statements that will write to several regulatory agencies for possible implementations in the ADR landscape. We encourage everyone to stay engaged Use the chat box for your questions and make the most of the opportunity to learn from our distinguished speaker. Once again, thank you all for joining, and we welcome our esteemed panelists. So I will just yield the floor to Professor Olushola Olujobi for his presentation. Prof, sir.
Thank you so much for inviting me. It's a great privilege. In fact, it's a great privilege.
It's a pleasure having you
It's
with
an
us,
honor
sir.
to be your miss. Thank you so much. It is a great, profound honor.
You can proceed,
and genuine delight that I participate in this important discourse on alternative dispute resolution and the energy transition, emerging trend, mining and renewable disputes. Before I go to the topic, to the webinar proper, let me give thanks for giving me the privilege to be your miss at the outset. I wish to extend my deep gratitude to the distinguished founder and the principal partner, Dr. Olisa Bakoba, SAN, the entire organizing team of this timely webinar, Mr. Uroko Agada Esquire, Mr. Emmanuel, Ms. Beverly Abakoba, Dr. Erima Uri, and the host of others. I extend my gratitude to everyone, all the participants, for giving me the privilege to be here today. I'm so delighted. Your commitment to fostering intellectual exchange and shaping conversation on law and policy in critical sectors such as energy and natural resources is highly commendable. May your vision continue to be enriched with wisdom, creativity, and transformative innovations that will not only influence the legal profession, but also leave a lasting impact on global development. I must also record my sincere appreciation to my mentor, Professor Damilola Sunday Olawi, SAN, the Deputy Vice Chancellor Academics, Research, Innovation, and Strategic Partnership, ARIFS, whose unavoidable absence has created the honorable privilege for me to represent him here today. His unrelenting pursuit of excellence in energy law and sustainable development continue to inspire many scholars across the globe. Even my path, I'm grateful for this trust and confidence, and the guidance has always been given to me. As we all know, dispute has always been an intrinsic part of human engagement, particularly where resources, power, and competing interests converge. Within the energy sector, long defined by the extraction of finite resources, now increasingly by the global shift toward renewable energy, the need for efficient and credible dispute resolution mechanism has become a pressing need than ever. As the world is transiting from fossil fuel dependent order to a low carbon energy, conflict are surfacing not only on diminishing petroleum resources, but also around the governance of renewable energy projects, mining activities for critical minerals, and equitable distribution of environmental burdens and benefits. Disputes, as we all know, are basic feature of human interaction, particularly where resources, power, and competing interests overlaps. The world is transiting from fossil fuel based to a low carbon energy future. Conflicts are emerging, and conflicts are unavoidable. Even the diminishing petroleum resources are also issues that cause for all lands to be on deck for us to rejig our laws in conformity with the global desire for clean sources of energy, which focus on renewable energy projects, mining, considering the adverse effects on the climate and the volatility of crude oil price. The detrimental consequence of fossil fuel dependence has occasioned climate instability, ecological degradation, food insecurity, crude oil price volatility, and other economic shocks. This has created the need for the world to decarbonize. A clean environment, viable alternative in conformity with the SCG 7, 13, and Paris Agreement 2015, and the UNFCCC, United Nations Framework Convention on Climate Change, is sacrosanct, and we cannot afford to lean back as a country. We must rejig our law in conformity with these international legal frameworks. The energy transition emerging trend in mining and renewable disputes has become a very serious tension among the host communities, particularly the Niger Delta. Energy firms, contractual disagreement in cross-border renewable projects, dispute over oil exploitation and critical minerals such as copper, cobalt, among others. Ownership of disputes, contractual disagreements, land ownership disputes, title disputes, royalty and revenue sharing disputes, issue of taxation, marketing and transportation, pollution, merger and acquisition, divestment and regulatory compliance. These, among others, are some of the issues and some of the tensions and conflicts arising from fossil fuel and even the energy transition. And the need for us to rejig our laws in conformity with the new trend, with the new disputes arising from the energy transition. Nigeria cannot afford to lean back. We must do a lot to ensure that all these disputes emerging are resolved amicably, not through litigation, through conventional litigation, but through ADR, to ensure that there is a win-win among the parties. Importance of arbitration in the African energy and mining sector. One, litigation is no longer fashionable. It has become an old school because it's energy sapping, time wasting, resource depletion. Hence the need for us to accommodate ADR, which can put an end to protracted and timelines rigidity of traditional litigation. It promotes confidentiality, commercial sensitive information and data. It brings about confidentiality, privacy, and the procedures are flexible, and it's globally recognized by New York conventions and other international legal frameworks. It has capacity to accommodate multiple parties, multiple issues, and promote. It allows the parties to regulate the processes by appointing their own arbitrators, their own panels, their own experts. Preservation of business relationship, because in litigation, once parties are in court, relationship becomes soil. You don't go to court and later become friends. But ADR ensure amicable resolution of the disputes. Parties can later maintain their business relationship. It expedites resolution of complex disputes amicably and expeditiously. Reduction of both government tensions, particularly in the Niger Delta area. It also promotes cross-border enforceabilities of the award given by the ADR panel or tribunal, stabilizing mechanism for investment, security, and sustainability, among others. ADR is relatively cheaper. A market trend in energy and mining arbitration in the era of global energy transition. Issues on legislative and regulatory drivers of dispute expansion, judicial recognition of environmental and climate rights, as was said in the case of COP versus NNPC, Bemire versus Shell, among others. These are classical cases where the court has given verdicts that environmental, clean and healthy environments are now human rights that must be protected. That the provision of Section 20 need to be amended so that pollution should be what? There should be remedy for environmental pollution. Once all multinational oil and gas companies pollute the environment, they should be made to pay and clean up the environment polluted. It's no longer a matter of choice. It's a necessity. Because the adverse effect of climate change is a global concern. It has raised issue that all lands must be on deck. Nigeria needs to amend its laws in conformity with this international legal framework, the Paris Agreement 2015 and the UNFCCC 1992. And the need for work to diversify from fossil fuel-based energy to renewable energy sources, which cannot be easily depleted, which is energy friendly, which is eco-friendly, which is affordable, which is cannot be easily depleted, and which is what is the global need, is the global ambition, is the global aspiration. That's what the world is doing. We cannot afford to lean back. We must do the same thing. This puts emerging trend in energy and mining arbitration in the era of global energy transition. The commissioning related disputes, the rise in environmental and social governance standards, and the proliferation of emerging disputes. Hence, the need for comprehensive legislative legal framework, issue on local content, and mandatory requirements in the energy transition. As was said, the Local Content Development Act 2010, which provides that the essence of Local Content Development Act 2010 is to build local capacity, to ensure that we use our local resources, so that employment of the local host communities, 51% ratio in the share allocation to indigenous citizens. The rationale for this is to build local capacity, to ensure that we do what we call technology transfer. We build local capacity. We must not only give our resources to foreigners, we must also build local capacity, indigenous empowerment. So this is consistent with local content legal regime, with international trade, investment regime, contractual disagreements, particularly under joint venture agreements, production sharing contracts, financial obligations, and operating procedures. Contentious issue on engineering design, project execution, delay linked to supply chain, and local participation requirements. These are issues of local content. Divergent position on currency of payments. Are we paying dollars? Are we paying naira? Taxation issue, taxation dispute, insurance dispute, ecological liability, and labor standard. These are in conformity with the Geneva Conventions on ADR, on the continental shelf, on the protection of the environment. UNCLOS Article 60, Article 76, 194, 197, 280 impose duty on states to prevent marine pollution. All these are emerging disputes in the oil and gas sector, considering the transition to low carbon of energy. And ADR can resolve this amicably. Looking at the international legal framework, such as the National Maritime Organization, Guideline IMO 1989, removal of offshore installations, the New York Convention 1958, officially titled United Nations Convention on Recognition and Enforcement of Arbitral Award. The 1984 Abidjan Convention on the regional context, the West Africa Central Region. Australia also have another thing, as we have the Commissioning Trust Fund under the PIA 2021. The Commissioning Trust Fund enabled the government to resort to that fund in the event multinational oil and gas company fail to carry out their decommissioning responsibility. Decommissioning is a process of removing disused assets or infrastructure, such the expiration of your operations as an oil and gas company. Most times they default. And once they default, this obligation reverts back to the state. Now, like other advanced countries like Australia, they have what we call callback, and they also have it in UK. What Nigeria have is the Commissioning Trust Fund. This Commissioning Trust Fund, most oil and gas companies, they're not complying with it. And this also raises a lot of disputes currently that must be dealt with via ADR rather than litigation. Because litigation is energy sapping, time wasting, resources depletion, and it brings about bad blood. Activity. The Organization for the Harmonization of Business Law in Africa, OHADA, 1993, came to unify business laws across West Africa and Central Africa. The Common Court of Justice Arbitration, CCJ, recognized arbitration as the center. Its mandate is to provide uniform jurisprudential foundation in supporting commercial arbitration, thereby strengthening investors' confidence in the energy operation and mining sector in Nigeria. National Framework on Arbitration in Nigeria. The Constitution, as amended, is the grand norm, but the Constitution is silent on arbitration as a dispute resolution mechanism in the energy industry, particularly mining. Section 6, sub 6, paragraph B, vests judicial power broadly in the court. However, section 251, sub 1 of the same Constitution grants Federal High Court exclusive jurisdiction on energy resources to resolve matters related to mining, renewable energy, among others. The PIA, notably section 232, sub 1, paragraph 14, and section 233, sub 1, sub 12, 232, provide provision for decommissioning and abandonment. It's important to give the accelerated peace and resolving arbitration, these commissioning issues through arbitration, because it's faster. It brings about Senate resolution of the dispute among the disputants. The Arbitration and Mediation Act 2023, which repeal the Arbitration and Mediation Conciliation Act 1988, this bring the current legal framework regulating the arbitration in Nigeria. It replaced the obsolete Arbitration Conciliation Act. It brings a lot of innovations. Key innovations under the 2023 AMA, Award Review Tribunal, which is novel. It raised concerns about potential delay in finality. Thank God for this innovation. However, in every rule, there's always an exception. And every law has their own challenges, their own lacunas. One of the flaws is that it raised concerns about the finality, especially in the oil and gas sector that is time sensitive. Now, you set up a Award Review Tribunal under the AMA 2023. The Award Review Tribunal may take time. After you have finished arbitration, you have given an award. And it is expected that a litigant or a disputant should harvest the fruit of his labor. Once award has been given by a tribunal and is subject to a review by an Award Review Tribunal, it takes time and it may delay the finality of the award given. Energy, arbitrators, and interim mayors. The Arbitration Amendment Act 2023 clear procedure of emergency reliefs and enforcement of interim measures, and also provide for third-party funding, which is a novel innovation. Legitimizing external financing of arbitration, encourage access to justice in high-value disputes such as energy sector, arbitrator immunity and default in appointing by the appointing authority. These provisions or these innovations in the AMA 2023 foster efficiency and protect arbitral independence. However, there's a challenge. Most times there can be war interference. Grant for setting aside award was also stated. The Act narrowed the basis for judicial interference, promoting finality while reflecting international conventions like the New York Conventions. The Nigeria Mining Act 2007 established a structural framework for addressing disputes between mineral title holders, the states, Section 14 and Sub 1 in particular, emphasize disagreement concerning the interpretation and enforcement arising from regulation or the terms of mineral title must first of all be referred to an arbitration panel for negotiation, for amicable negotiation and resolution of the dispute. However, it also has its own challenges too. The challenges has also been weak enforcement, lack of political will and sincerity to enforce the law. Then we also have the Nigerian Liquefied Natural Gas Fiscal Incentive Guarantee Assurance Act. The Act offers a distinctive dispute resolution mechanism aimed at protecting foreign investors in Nigeria oil and gas sector. What is the flaw of this act? The flaw is that weak enforcement, lack of political will to enforce this law religiously, to promote the resolution amicably among disputants, particularly in the oil and gas and mineral sector. Then we have Oil Pipeline Act 2004, which provides dispute arises between the parties. The Minister of Petroleum has the right to resolve the dispute between licensees amicably. However, these provisions have been abused. Even the act itself is no longer fashionable. It has become archaic, considering the energy transition, considering the climate protection era. The act failed to make provision for these new developments. When you need for the act to be reformed, it conforms to the current trend and practices, and it conforms to the Paris Agreement 2015 and the UNFCCC Convention 1992. Nigerian Oil and Gas Industry Content Development Act 2010. The act is a landmark attempt to strengthen indigenous participation in the nation's petroleum sector. However, the flaw of the act is that it only made provision for the oil and gas sector. It failed to consider other sensitive sector that would have empowered, that would have built capacity, that would have encouraged indigenous capacity, that would have boosted the economy of the country. It resists only to the petroleum industry, thereby excluding other critical sectors of the economy, whereby similar content policies will stimulate growth and capacity building. Discretion of the vested in the minister under the Petroleum Industry Act may affect its efficacy, because the minister most times they abuse their discretionary power. International and national institutional framework for arbitration in Nigeria. International Center for Settlement of Investment Disputes, Chartered Dispute of Arbitrator UK and the Nigeria, Lagos City Multi-Door Court. I can't forget, because they have resolved several disputes excellently, and their award has been implemented. There are challenges in practice and enforcement of arbitration in Africa, particularly in energy and mining disputes. Inadequate incorporation of arbitration process in contracts by lawyers law firms and by the parties. Conflict of laws, governing law dilemmas, rising cost of arbitration. Yes, arbitration is cheap, but at times it can be expensive because you have to foot the bill of the arbitrators, their hotel bills, their flight tickets, and this may be on the other side for some of the parties involved, the disputants. Judicial intervention and enforcement of our bottlenecks, because some of the time you still need to resort to the court to enforce the award. Judicial, you need to require judicial leave for enforcement of arbitral award. This is another bottleneck that may affect a disputant to harvest the fruit of his labor. It even may delay the award. Abuse of preliminary objections and judicial challenges. Most time lawyers bring preliminary objections against the award after an award has been given to buy time to delay the implementation or enforcement of such an award. Hence the need for us to provide the following recommendations. One, the need to strengthen arbitration in Africa, expanding arbitrability. It's not every matter that can be resolved through arbitration, like criminal matters, bankruptcy, taxation, insolvency, among others. Hence the need for the scope of arbitrability of the AMA to be expanded to cover other matters, particularly insolvency, taxation, among others. Even criminal matters. I've been several forums where I've raised it. Even ADR to extend to criminal matters. Because during the olden days, our headers resolve criminal matters through ADR, through negotiations and mediation. We can also extend the same thing. Some countries have started doing that too. Ask the suspects, the defendants, to compensate. If I thought he will be ostracized in the society, but let him compensate. Thank God for the addition of Criminal Justice Act 2015. There's a provision for compensation now, but hence the need for further reform to accommodate criminal matters, insolvency, taxation, among others. Implement standard and ethics, capacity building among the arbitrators, frequent training and retraining, drafting of arbitration of agreements need to be precise. There's a need for us to enhance capacity in that perspective. For drafters, lawyers, ADR parties to include arbitration clauses in the agreements, enforceable arbitration clauses in the agreement that are workable, that are enforceable. Energy transition and climate policy in Nigeria must also be incorporated into their agreements. You need to include provision for climate policies, climate obligations, climate protection obligations. Hence, the need for accelerated reduction of gas flaring too, and promotion of sustainable natural gas utilization. Discouragement of deforestation, adoption of fuel-efficient technologies to improve food security, reduce environmental harms, especially in the energy and mining sector. Enactment of comprehensive statutory framework for low-carbon energy deployment and usage, strategic planning, continuous human capacity development, and sustainable investment in renewable energy technologies, such as solar panel, solar battery, among others. Government must increase its sincere commitment, support robust financing mechanism, drive transition from fossil fuel to clean sources of energy. These, among other recommendations, will be so useful in ensuring the efficacy of arbitration in the energy and mining sector. In conclusion, there must not be passive recipients of global arbitration practice. It should be proactively enact an energy transition sensitive ADR framework that is responsive to climate obligations, cognizant of local realities or needs and circumstances, and aligned with global best practices, such as adaptive approach that will ensure that disputes don't only derail, it must be time sensitive, conformity with energy transition objective and projects, reinforce regulatory certainty, promote investors' confidence, and it must promote sustainable development in the sense that ADR is not only an option, but a necessity, a mechanism for resolving conflicts, but also a strategy too for safeguarding Africa's pathway towards just, orderly, equitable energy future. Thank you for your attention. God bless.
Thank you, Professor Olushola Olujobi. That was a magnifying, electric presentation. I almost feel as if you've actually you've answered all the questions. But honestly, it was so enlightening. You took us on a full ride from the foundations of arbitration, the benefits, where the challenges lie in the industry. You took us through a fantastic overview of the laws that currently exist and the institutions that are set up to adequately arbitrate. However, you've also rightly pointed out so many conflicts of laws that exist as between the legislation and the lacunas that also exist, which have not with trends and changes and quite frankly, the evolution of the energy sector. The energy sector has gone quite far ahead of the current legislation. So just want to say a fantastic show of appreciation from all of us at OAL for setting the scene, as it were, for what I believe is going to be a truly engaging, instructive, and enlightening webinar. So without further ado, I would like to just introduce myself very briefly. My name is Janya, and I, apart from all the other things that I do around sports, entertainment, and tech, I also very, very passionate and an arbitrator and mediator as well. And I head up the ADR practice here at OAL. And to have such esteemed, distinguished guests, eminent guests amongst us that will be professionals, that will be taking us through the intricacies of ADR and the energy transition. Mining and renewable energy is simply a privilege that we don't take for granted. So thank you so much for that insightful presentation. So I would like to ask, to turn my questions, of course, firstly to Professor Olujobi, because he raised some very key things. And I think I want to, further pull out some of the major gems that you Professor, you rightly pointed out the lacunas that exist in quite a few pieces of legislation that we have. You've talked about the Petroleum Act, you've talked about local content legislation, you've talked about how these pieces of legislation were not created with the evolution of these sectors in mind. Now, we are here not just to learn, but also to proffer solutions for a way forward. You've talked on unification of legislation. You've also talked about conflict. I think what I would say to you is, in an ideal world, what would be your priority, Professor, if today you had the opportunity to make some major change? Because at the end of the day, it's a huge menu of multiple challenges. But in the words of Warren Buffett, sometimes we just need to prioritize and pick the top 5. So what would you prioritize in your esteemed view, a way forward when looking at the challenges on a broader scale, where we have lacunas in the legislation and some arbitral institutions not necessarily making provision to adequately arbitrate in some areas. So I think that's the first thing I would ask you. Where would you prioritize today focus? And this is an open question to people in government that are listening, the policymakers that are listening, because like my colleague Emmanuel said, we really want a lot of valid points, suggestions here raised today to be distilled into a paper that we can forward to the powers that be. So what would you say, Professor, would be a great starting point? And I know this is not something that we can solve overnight, but at least where would you start? We'll take it from there. Thank you.
Thank you. That's a wonderful question. Wow, where are we starting from? I haven't seen the red flags, the lacunas, the pitfalls. The first thing I humbly suggest is that there's a need for reform of our legal frameworks. Our legal framework needs to be reformed in conformity with the United Nations Framework Convention on Climate Change, UNFCCC 1992, the Paris Agreement 2015, our Climate Change Act, wonderful. Our national law, the grand norm, the primary law in Nigeria is the Climate Change Act 2021. Fantastic. But there's a need for that law to be amended because the act was amended without having 100% in mind of energy transition. It was amended, it was enacted without thinking of the adverse effect of climate change 100%. Hence the need for one, the National Council on climate change enacted under the law, set up under the Climate Change Act 2021 to enforce the law, to be empowered, right peg, it's not square peg in a round hole, right person, and should be member of that, should be a driver of that law. That law needs to be rejigged 100% in conformity with the Paris Agreement 2015 and UNFCCC. And the driver must be an expert. Either it's an environmental engineer or an environmental or national resources economist, or it's a lawyer, an environmental lawyer. Somebody who's an expert in the area of concern. And composition of that member of National Council is overwhelming. The composition is not, it's not adequately formed. It's not composition of experts. The composition is full of, because I want to please my political proteges, my political followers. It should not be, it should be based on merits, because the adverse effect of climate change is all hands should be on deck to combat the adverse effect of climate change, because everybody's stress is at stake. The federal government needs to do a lot. The federal government needs to be sincere. There must be need for sincere commitment to protect the environment. We must prioritize environmental interests above economic interests. We need oil because our economy depends on oil. No wonder. But there is the need for us to prioritize environmental protection, conservation above economic interests. 3, there is a need for the federal government to look inward, support utilization of renewable energy. Thank God for Bola Tinubu. Bola Ahmed Tinubu is driving CNG seriously. Presidential drive for initiative on CNG utilization, because most of the trucks are started using it. But there's a need for us to do more for the utilization of compressed natural gas. Nigeria is more of a gas nation than crude oil. We have advanced, we have large deposits of natural gas in the country. We must use all these renewable energy sources: solar, wind, biomass, hydrogen, even hydrogen. We have not started using hydrogen as expected in this country. We must diversify. There's a need for us to diversify our energy sources. There's a need for energy mix. We must disrupt fossil fuel usage and move to clean sources of energy, and move to renewable energy sources, and move to utilization of hydrogen, and also concentrate on exploitation of our mineral resources like mining, copper, gold, earth oil. All these things are abundantly deposited in the country, which we have not used. Even bitumen, we have them. These extractive resources are abundantly in the country, which we have underutilized. There is a need for us to diversify and be looking inward because of the crude oil price volatility. International markets, we cannot subject ourselves to global shocks, economic shock any longer, so that we won't go into recession, as we nearly did. We have enough resources, both human capacity and extractive resources in the country. We need to focus on this, particularly minerals, mining, renewable energy resources, and we have abundant renewable energy technology that can be used to produce renewable energy technologies in the country abundantly. But federal government is not using, is not focusing on it. All our focus purely crude oil. But don't forget, crude oil is no longer fashionable. The world is transiting from fossil fuel to renewable energy sources, and we cannot afford to lean back. We must rejig our law in conformity with these international frameworks, and we must look inward. We must build capacity. There must be training and retraining, and there must be sincere commitment on the part of federal government to drive clean sources of energy, particularly renewable energy. We have solar in Kano, solar Kano's, this level of sun in Kano enough generate electricity that will be useful for the people in that particular area in the north. But we're not looking inward. We concentrate on hydro. No! If we can even generate hydrogen to generate electricity, even solar, wind, biomass, solar, even wastage, our debris, when we finish it, all those food, we use to compress it to solve our power sector's epileptic power supply in the country. Even mining too. We need to look inward to combat illicit mining activities in the country. The illicit miners, illicit artisan miners. The federal government need to amend our Mineral and Mining Act 2007 to combat illicit mining activities. Hence the need for what? Adoption of technologies, modern technology, surveillance, monitoring of technologies, to monitor all these activities of these illegal miners, to revoke their licenses, to punish them severely, to serve as deterrence to others. So that the money coming to the money earning from mining will go directly to the federal government rather than some warlords, rather than some individuals who are taking advantage of this affordable deposit in their domain without revisiting the money to the federal government. You license artisan miners, but see, they are going beyond, they are abusing their license provisions, they are abusing the terms and conditions of their license. Once they do and they are caught, they should be sanctioned. But federal government appear to be leaning back. They are not doing enough to combat these illicit mining activities, particularly in Ilesha, in Nasarawa, in Kano. The money that will accrue to the federal government is accruing to individuals. And this enough money is enough to turn around the destiny of this country. Some nations don't even have up to what we have, and they are doing well. Look at Dubai. You go to Dubai, it's as if you are in another world entirely. You'll be shocked what do they have. They don't even have as much as we have. Go to Norway too. You'll be shocked what they have. They don't have up to what we have. But because they are organized, they are structured, they are sincere, they are committed, they are strong-willed to drive to manage their resources, to prevent resource costs, to prevent a Dutch cost business. Even Ghana, they just discovered in 2010. They started exploration in 2012, and they are managing their oil very well. We could do the same thing. Manage our natural resources excellently. If you do, you and I, it will benefit us. It will combat all these rent-seeking activities, corruption, and all these antisocial behaviors. If the government could be sincere and align its policy with international global framework, it will be useful for Nigeria to promote sustainability, development, growth, and boost the economy.
Thank you, Professor. Thank you very much. And on to your point, which I've picked out from that fantastic submission on we need to do more capacity building, we need to do training. I would like to bring in at this point Dr. Erima Orie to the fore. You're very welcome, madam. It's a pleasure and an honor to have you here with us. And I just want to piggyback on what Professor said about this need for capacity building. And one thing I just want to avert to all our minds to before I ask you the question is, we often just think about ADR in terms of the arbitrators, the mediators, conciliators, and negotiators, and also the council. But actually, there's a role for experts to play. And this brings me to my question. Environmental disputes along the lines of energy, in mining, renewable, often require scientific and technical evidence, which necessitates the role of an expert. In your opinion, Dr. Orie, would you say that there are enough environmental experts in Nigeria and actually within Africa as a whole? Because now we're talking about training. We need to train up. We need more capacity building. ADR is the preferred mechanism. But we also need to be mindful that we are also trying to all enter this space and have less foreign ADR professionals come into our space and do our work on our behalf. So, say to this, Madam Dr. Orie. Thank you.
Thank you very much for the opportunity. It's actually a privilege to be among scholars, sharing knowledge and learning from one another. Thank you, the law firm of Dr. Bakova, for this opportunity, and for Beverly too for reaching out to me. Back to your question on whether there is a dearth of legal expertise in this area. I guess that is your question. I hope I heard you correctly. There is no doubt that there is a dearth of experts in this area. I mean, even if you look at the entire lawyers, yes, assuming we have over 100 million, I don't know what the figure is in Nigeria. How many of these lawyers are experts in environmental law? How many have appreciation of environmental issues? Even among the judges, so it's a very, very big problem. Being a lawyer is one thing, but being one who is knowledgeable in environmental issues, who is an expert, who understands the nature of environmental disputes, because environmental disputes are peculiar in nature. They are not like other disputes. I mean, if you have commercial matters, a commercial matter, it could be there for the next 20 years. Nothing happens. Is either money had and received, is either dispute over legal documents concerning that transaction. It remains so. But environmental matters, disputes are peculiar. In terms of the impact, they are very, very indeterminate. They are enduring. The impact can spread like wildfire. The effect on people can last for generations unborn. I mean, there are cases now on environmental matters that are for unborn generation, because they have seen that these issues are not just on the surface. That some could be there for the next 50 years. Some could be there for the next 100 years. So you need an expert in giving judgment. That's also happened in the pulp mill case, that the Permanent Court of Justice, even when he had about 5,000 pages of documents to look at, but they could not comprehend the nature, the peculiar nature of environmental dispute. And that case that wrong judgment was based on lack of knowledge of this expertise. So we need experts on the panel of arbitrators, experts even as judges, experts as lawyers, experts who are lawyers, who will be able to appreciate the issues concerning environmental disputes in terms of the character and nature of environmental dispute, and also the scientific content. Because some cases are lost because the seismograph case, for instance, was lost because the party didn't have $1 million to consult and pay an expert, and he lost because he needed to explain that the vibration was part of what caused the harm. And the judge was at a miss. He said he doesn't understand that science. And the man, not being able to engage a scientist and an expert in that area, lost. So, but if the decision would have been different, if that judge were to be somebody who had an environmental content, were to be schooled or knowledgeable in environmental space. So that is why we need as many people as possible. In India, that is what is happening now. You have the green course populated by experts. It's not an every comma affair. Every lawyer is not going to be there. And not just that they are lawyers, that they have environmental expertise, they also stay for a minimum. In India, you don't get employed, you don't get a space, except you have 15 years of experience. You don't get appointed to the Green Court, except you have 15 years of experience in science-related areas, in green-related areas, so that you'll be able to appreciate the issues at stake. That is why today in India, you see that India is making progressive steps, unlike what we have in Nigeria. We do one step forward and then 10 steps backwards. What is the issue? Either there's no political will. I was happy when the professor was talking about political will. Either there's no political will to drive it, or there is absolute total ignorance of environmental issues. The environmental content of a particular case is very relevant to how you decide that case, to how you analyze that case, and to how you implement it. That is the problem we're having in Ogoni up to today. They're talking of now remediation. The issue is gone beyond remediation. But because we do not understand, say, oh, they've given them 1 billion, they've given them 11 billion, those will not solve anything. Because for the next 50 years, all those lands in Ogoni will they are useless already, and they will not be usable. So we need as many people as possible. There's need for environmental education. There's need for environmental education, an urgent need for Nigeria. Or very, very urgent need in Nigeria.
Thank you, Doctor. And to just come back to your point about that need, and it's quite unfortunate to hear of the example you gave of someone who lost a case potentially because they didn't have access or could not afford the services of an expert. What would you say people should do if they want to acquire those skills, if they want to do, say, pro bono? Is that something that's a possibility to attain the skills and in the process do pro bono work or be on pro bono panels? Do those things exist? Because I'm sure the people listening today are thinking, I would like to get involved, but don't even know where to start as an expert, since you have confirmed that there is a dearth of this expertise within, I would say, Nigeria. So I don't know what your feedback could be on that.
Yeah, thank you for the question. There are several platforms now for at least basic education. Even if you are not a lawyer, if you go online, you could learn one or two things about environmental degradation and environmental protection. What causes it? How can it be averted? Who are the stakeholders? What role can I play? Those are the basic things that one will begin to information that one will begin to acquire. In terms of pro bono, yes, a number of lawyers are also handling pro bono cases on those issues. But sometimes it also borders on awareness. The stakeholder, the locals are not even aware of the fact that they need an expert. They will just think that many of them think that just any lawyer can do. Any lawyer is a lawyer. Oh, that's all right. It's an arbitrator, that's all right. Even when he's an arbitrator, you need an arbitrator who is an expert in environmental law, who understands the science of the environment, who is able to dissect and know that this decision, it is not just for today, but I'm taking a decision, I'm giving an award that will change the course of things in the next 20 years, in the next 30 years. I'm giving an award that can revolutionize the community within a twinkle of an eye. For instance, if you're given an award concerning the course of a river, and that river is polluted and people are not aware, and is suddenly diverted, or people are allowed to take water out of it, you can imagine the cost of the ripple effect in terms of health challenges that people in that area will have within a space of 1 month, a space of 2 years. And then some women will not even be reproductive anymore on account of such issues. So you have situations, you have permanent damage, you have the ecosystem suffering. Turtle, for instance, they live on, their timing is regulated by vibrations. The cost of vibrations around where they are, that tells them when their heat is on, their reproductive period is on. For them to move to the hinterland, they don't lay, the turtle do not lay inside the water. They go to the wetlands. They lay their eggs there and hatch them there. So if the turtle miscalculates on when to leave the water, it will mean that all the turtle that we produce will be lost in the water. That is just one small, tiny example. The fingerlings also, they do that. The fishes, they go to the wetlands. The creeks, you find them going to have their nursery there, the fishery there. So once you miss those calculations for them, once they miss it, because the ecosystem has been tampered with, it's a problem. So as an arbitrator giving an award, as a judge, a Greek court judge giving an award, you have to be conscious of the fact that you are protecting the earth. You are sitting on something that could boomerang, and there's a sense of urgency in it. So there are several avenues that we can learn. For me, there's a platform I'm also using that's for EcoConnect. Now and then I come on and I teach on environmental issues and environmental protection. People are free to join. It's unpaid and it's for us to share knowledge. Thank you.
Thank you. Thank you so much, Doctor. That was very insightful, and we will certainly get the details of where you are teaching so we can share it with the audience. Again, we're here to disseminate knowledge and encourage as many lawyers into this space. I would now like to turn my attention to Mr. Agada. Thank you very much. And this is a beautiful segue because Dr. Orie talked about the importance of having expert arbitrators with the knowledge, background, particularly in scientific areas as it relates to energy and mining and renewables. So you yourself, you are a lawyer, you're also a chartered arbitrator in mining. I think a very practical question to ask you is, what steps can parties take to ensure that these disputes are seamless, cost efficient? I did hear Dr. Orie say things that are so pertinent. Some parties don't even know that there's something called arbitration in the first place. They don't even know what an expert is. So what would you say to perhaps people watching who may not be lawyers. I can't assume everybody in this audience is a lawyer. But if a dispute arises, what type of practical suggestions would you give as an arbitrator, chartered arbitrator in that field, about how to keep things seamless, practical, efficient communications between parties? So I'll leave you to handle that question. Thank you.
Thank you very much. I want to use this opportunity to extend my appreciation to Agbako for giving me this opportunity to be part of the panel. As a lawyer and a chartered arbitrator, I will commend the following steps and to ensure ADR, the mining renewable disputes, efficient, cost-effective, and enforceable. This is my line of discourse. There are 4 categories. We have a pre-dispute planning category. We have a dispute resolution process. We have enforceability and efficiency. We also have post-dispute consideration. I've categorized it into this category for simplicity. So, in the pre-dispute planning stage, imperative that there should be an incorporation of clear ADR clauses in contract. That is what makes it arbitrable. If there are no clauses, ADR clauses in contract, there's no way you can incorporate it into an ADR procedure. So in this regard, it is imperative that at the onset, at the negotiation stage, at the contract formation stages, contract ADR clauses should be included. 2, then we should choose or select established ADR rules. For instance, the ICC rules, the LTIA rules, or on CITRA to govern the process. It is at the beginning stage that we determine which of the rules apply. Then the third part of the pre-dispute planning process is also to designate the seat. Where is the venue or the seat of arbitration? It is very important because it goes to the issue of jurisdiction. So at the early stage, we should be able to determine which seat, if there is a dispute or if dispute arises, which seat is adequate for determining dispute. For instance, where the parties are Nigerian or in Nigeria, and the dispute arises in Nigeria, and maybe as it goes, most people can say, okay, let us have this dispute settled at the London Court of International Arbitration. If you consider the cost that it will take to determine such dispute, it's going to be out of reach for the disputant, especially where it does not have international inflation. So these are disputes or to be given during the pre-dispute planning. Then in the dispute resolution stage, it is also important, as Dr. Ore stated, to appoint or select experienced neutrals. For instance, in renewable energy, there are novel technologies used in this separation of renewable energy because of the cost implication, and that is what makes the cost to be very high. So if you bring in someone who does not have the requisite knowledge in this area, it's going to blow everything up. And instead of minimizing cost, it will rather exceed what is expected by the party. So it's very important to appoint experienced neutrals such as arbitrators, mediators, negotiators, and others in mining and renewable energy disputes. Then we should also streamline the procedure. That is the second part of the dispute stage. Agree on efficient procedures such as document-only arbitration or early neutral evaluation. Parties can, from the early stage, decide to say, okay, let us use documents in hearing disputes, in which case there will be no need for calling evidence, calling parties to come and adopt and all that. Once you submit, the neutral to take a look at the documents before and form an opinion or render an award based on those documents. And it makes it quite seamless. Then the enforceability and efficiency stage. We have to ensure that the awards are enforceable. For instance, as Professor Olushola said, criminal issues are not arbitrable. So where in a mining dispute, criminal issues have been identified, you have to look at it whether these are arbitrable matters before you go ahead with it. Otherwise, it will render the whole exercise null and void at the long run. So we should comply with either the New York Convention or any relevant national laws to ensure that the awards being rendered are enforceable. Then the use of technology. Leveraging technology is very, very essential, such as virtual hearings, digital document management to enhance efficiency and reduce costs. For instance, assuming the seat of arbitration is in the London Court of International Arbitration, where you have to pack all the voluminous documents to London. For instance, there are flight issues such as maybe allowable kilograms of luggage that you can carry. So when you contaminate some of this excess luggage, it will also increase or bear its burden on the cost of the arbitration process. So if you use or deploy technology such as virtual hearing, there will be need to transport those hard copies of voluminous documents that are meant to be used for the arbitration, in which case you are reducing the cost of the arbitration. Then we should also agree on cost-effective measures such as limiting document production or using summary procedures. Using summary procedures to enhance some of these unnecessary application, filing of preliminary objections and all that. So when you decide to use summary procedures, you will now eliminate some of those unnecessary burdens on the process. Then the third aspect, which is the post-judgment consideration, is it is important that we monitor and enforce awards, ensure compliance with awards and judgments, review and revise contracts, update contracts to reflect lessons learned and improve future dispute resolution processes. For instance, when you have handled an arbitration, there are lessons, practical lessons that you will learn. As time goes on, you incorporate some of these practical lessons that you have learned on the subsequent ones that you have to use. Then maintain relationships, foster ongoing relationships between parties to promote future collaboration. In court matters, it's more of you see that relationships are not being fostered. But arbitration, you can develop friendships, which will help you when you need some materials. You can call, oh, I've appeared with this arbitrator before, let me give him a call. And he's likely to give you the concession. So by following this step, the switching parties can ensure ADR in mining or renewable disputes remain efficient, cost-effective, and enforceable. Thank you very much.
Thank you very much, Mr. Agada. And just to rehab some of the excellent points you made, we all know as lawyers that the way a dispute unfolds begins from the contract stage. And you rightly pointed out that very critical that the right ADR clauses are indeed inserted into these contracts. Failure to even put clauses into the contracts renders it not impossible, but definitely will be a bit of a tussle to even get to the arbitration stage. You've talked about the need to implement technology. We are living in a digital age, and we should be all using technology to reduce our costs for document management. Also talking of arbitral institution. Again, this is probably dependent on the clause itself. So let's all be very mindful about the clauses we draft and also the clauses that we agree to. Because if you agree for the LCIA to be the venue and not the seat, you can have an international view as well as an international seat. It can serve place. At the end of the day, sometimes these things can be managed by relationship building, and that's a very important role that I suppose the arbitrator can play by managing the sensibilities of both parties. And of course, you mentioned so many other things that it was quite a lot, but it's such a fantastic summary, and I really hope that the audience found it very insightful as I have. I would now like to turn to a different set of questions, which will address the trends, the risks, and the opportunities in the course of the energy transition that we are all in currently. And I will turn my question back to Prof. Olujobi. And that question is this. With renewable projects often involving cross-border investments, where do you see predictable, foreseeable jurisdictional conflicts? I mean, I think, I mean, for me, I do read on these and every other day, if it's not GAR or if it's not, the dailies or social media, you are just seeing cross-border issues. A country is dragging another country to court because of, you did mention, Prof. Olujobi, boundaries of licensing agreements are being breached. So many examples that we see today. Do you see this abating, or do you think that this even more? And how can lawyers, arbitrators, mediators, people who want to learn more about this area keep their, what's the right or fora to learn more about where all these disputes are cropping up? And could you give examples of disputes? I mean, if they're confidential, then of course we know you can't, but it's always good to keep things practical, particularly when it relates to Nigeria, Africa. So just to take it again, we're looking at the cross-border nature of investments, and we all know that Africa is where everybody's mind is. China is interested, the US is interested, Russia is interested. So where do you predict these foreseeable conflicts, and what can be done to prevent those conflicts? Thank you.
Thank you so much. What a wonderful question. Because that's the new trend. And we cannot afford to lean back. One, ADR is not a substitute for public law and environmental regulation. It's not a necessity. Legal instruments to resolve disputes amicably, to combat bad blood, feelings, and to ensure that the relationship is sustained. Transparency is very key. Disclosure of environmental data, access to justice, public interest. Let me start with the basic disputes. Decommissioning. Decommissioning is is one of the major issues. Decommissioning, because it's an obligation on the part of the company. Once they hands their operations to carry out the decommissioning exercise, often most oil companies abandon these obligations. And these are areas where people are now challenging. They are going to court. The host community interests are at stake. The whole state is at stake. The oil firm interest, the mining organization is at stake because it is a threat to biodiversity resources, to the environment, to sailing in the ocean. And this has raised a lot of issues. There's a lot of arbitration matters going on in respect of decommissioning obligations. Who is to decommission? The residual consequence of decommissioning. How are we going to resolve it? Payment of decommissioning fund. How are they resolving it? These are issues. One, local content issues. It's another issue too. Local content requirements. Because some have argued that this local content has contravened the provision of World Trade Organization, the provision of international obligations, cross-border, HAFTA, international obligation on trade. Hence the need for all this, for us to amend and rejig our laws to combat this new trend, this new dispute occasioned by climate change, energy transition. Then another dispute is this: contractual agreements arising from joint venture, production sharing contracts, risk service contracts, pollution, cleanup, remediation. These are disputes. Adequacy of the compensation, is it adequate enough? Jurisdiction, another issue is issue of jurisdiction. Which court has jurisdiction? Particularly on cross-border matters. Where is the proper forum for the party to arbitrate their matters? Is it in Nigeria? Because oil and gas and mining cross across jurisdictions. Where are we going to resolve our differences? Subject to the agreements. Is it expressly stated in the agreement? Is there an arbitration clause in the agreement? And in the absence of where the arbitration agreement is silent on all these issues, then there will be a dispute, which is better resolved through ADR because it's faster. It reduces hostility. It saves time. It promotes confidentiality. It is faster. Because litigations are protracted. Energy sapping, hostility. Then ADR is what? It's encompassing, it's flexible. Parties are in control of their disputes. They choose the arbitrators, they choose the venue, they choose the procedure. They decide who arbitrates over their matters. They decide who is the mediator. They decide who are the panel and what time the process will be on. These are issues, and we see have more issues, more disputes over a lot of issues, of the trendy issue disputes, like revenue sharing, taxation, especially taxation, royalty payments. These are issues. Unitization too, which is the area. No, people hardly talk about it. Unitization. Now, we have an oil. An oil has been allocated to me. An oil has been allocated to me. If you start drilling before me, we're not likely not to get anything. We're in the same area. Your own is like 20 kilometers away from me. If you start drilling before me, I won't get anything because your oil from you will migrate to my own. These are disputes. These are trendy disputes, which we must avert our mind to. How are we going to resolve it? It's better resolved through arbitration, so the party will now form unitization and drill together, put their resources together and drill. But before they agree to that, there will be disputes. If I start drinking before you, and you know there's an economic loss to you, you go to court. But it will take time. It will cause economic loss. It will bring about bad blood. But once there's a unitization, we agree. We'll put our resources together, put our experts together, then we'll start the drilling together and we'll share the resources together amicably. The profits, I will pay the royalty together, and we'll bear the risk and the loss together. What is another area we need to look at? Climate change too. Advancement of our activities, operations, drilling, mining activities on the environment. Now that the world is transiting to clean sources of energy, these are disputes arising from this new trend, this global vision, this global aspiration. We want to resolve it amicably to ensure that the parties live happily together, amicable resolution. These are issues. Then these cases that has been dealt with, Westernmost Land Mining OD in Canada. In that case, where investors contested Alberta decision to phase out coal-generating electricity by 2030, under the Climate Leadership Plan, Westernmost Land argued that the regulatory measure effectively curtailed the economic life of its mining operation and resulted in a discriminatory treatment. The company claimed that Alberta unlawfully favored certain coal-fired electricity producers by offering transition compensation while excluding Westernmost Land, which own only coal mines. Although the tribunal ultimately dismissed the case for lack of jurisdiction, the dispute is instructive. Hence, there will be dispute because of especially an economy that depends solely on fossil fuel, like Nigeria, like Angola, There will be disputes because our economy basically is fossil fuel based. Now, there's a transition for us to move from fossil fuel to renewable energy sources. So for clean sources of energy, there will be disputes, especially on what? Especially on oil licenses and subsisting oil licenses. If I have to migrate to the new era, if my license has not expired, for me to migrate, will I bear the liability in existence? Will I bear the incoming liability? How will I bear the liability? Party need to agree on this. These are likely issues, likely dispute, likely trend that will arise. Then in the case of John Agbemire in Nigeria context now, John Agbemire Shell versus Petroleum Development Company Limited and the Nigerian National Petroleum Company versus Attorney General of the Federation 2005, where the Federal High Court affirmed that routine practice of gas flaring in the Niger Delta violated constitutional protected rights to life, and practice of gas flaring in the Niger Delta violated constitutionally protected right to life and human right dignity and human dignity as well. As the right guarantee under the African Charter and human and people's rights. Why the court did not frame the matter strictly as climate change? The judgment nevertheless set a jurisprudential precedent by articulating environmental protection as an aspect of fundamental rights. This reasoning has since opened a pathway for recapitalizing the right to clean, healthy, and sustainable environment within the comprehensive discourse of human rights. Taken together, this development is a transformative direction in energy and natural resources law to align our laws with the Paris Agreement, which emphasizes on sustainable practices, emerging global consensus on arbitration. ADR mechanism should play a central role in addressing complex web of disputes in the energy and mining sector. In this respect, arbitration offers not only efficiency, neutrality, but flexible procedure for reconciling competing interests amicably. Particularly, it will give investors confidence, it will give the host community trust, it will give them a sense of belonging and participation. It will also ensure war. It will reduce hostility among the war, Niger Delta community, especially the youth. It will promote means of resolving their differences amicably. Then more, we still have this case too, which is also resolved through ADR. MS Man Holding, BV, and Kingdom of Netherlands. In that case, the Dutch government adopted a legislation mandating complete cessation of local fire electricity generation by 2030. These are current cases, measure intended to accelerate its national energy transition strategy. One of the affected investors initiated an arbitration proceeding, advanced a claim of 1.4 billion claim in dollar on the ground that the regulatory phase out amounted to an unlawful expropriation of his investment and a breach of protection guarantee under the Energy Charter Treaty, ECT. The tribunal is yet to render a final award on this matter. However, the case is an eye-opener on complex disputes that are increasingly likely to arise as a result of war, energy policy reform, and climate change commitments globally. Then we have another one, which are issues on ESG, social, environmental social responsibility governance, which we need to avert our mind to, that we need to reform our laws to be in conformity with the global frameworks and commitments. Local content and product mandatory requirements in energy transition is another dispute because some countries have their local content different. Some countries 50, some countries in Nigeria is 51. We must have 51 stake in the company. The indigenous capacity to be the indigenous capacity. For example, a foreign company is coming to Nigeria. The chair, the directorship must reserve for Nigeria. Nigeria must have at least not less than 51. Insurance must be done by Nigerian company and Nigerian companies. The lawyers must be Nigerian. These are issues. The company may not agree with this, especially in mining and renewable energy sector. They may not agree with this. These are issues they need to arbitrate upon. Another one is this mandatory procurement requirements. Some company favor foreign importation instead of using local materials and local resources. These are disputes that may likely arise in the current trend on energy transition and climate change. Then, preferential tariff, tax incentives, likely to raise issues, tax issues, especially considering the new tax regime in Nigeria. These are issues that will arise considering the energy transition. Then, contractual disagreement on joint ventures, financing obligations, operating procedures, mining licenses. These are issues and not arbitrary amendment of oil licenses and mining licenses. These are issues that will rise because now I've procured my license. The world is transitioning to renewable clean source of energy. I've paid my fees. You are annoying my license arbitrarily. I will go to court. If I didn't go to court, I'll go to an arbitral panel to get an award, to get my license reinstated or claim damages. These are issues. Especially the ongoing licensee or leaseholders, leasehold title or leasehold interest. These are issues that will arise. Then, no. Connection of local content rules with international arbitrations. There are issues because there must be an interlink, a connection in disputes. In the absence of this, there will be disputes. Because most of these investors are foreigners who are coming to stake their money, and their objective is to get good return for their investment. They are not for their Christmas. They are coming to invest. Then let's look at this case. Apache versus UK Investment Limited versus ESO Exploration Production Limited. It's an English commercial court clarified the scope of liability under the UK Petroleum Act 1998. The case turned on whether a buyer could be held liable for decommissioning while drilling after it had acquired assets from the seller. ESO argued that indemnity extended to all well. The court cited the approach, affirming that liability should rest with the party and have derived financial benefits from the installation. The decision underscored a key principle of decommissioning governance. Responsibility must follow the economic benefit derived from the exploitation. While global framework is increasingly coherent, significant gap remain particularly concerning residual liability, dynamics, ownerships, allocation of financial responsibility. These challenges are issues that may likely bring disputes in the new trend, the new era of energy transition, climate protection, and environmental work, conservation and protections. Then there's still more. Hence the need for us.
Thank you,
Hence
Prof.
the need for us to amend our laws to be in conformity with this new trend. Thank you.
Thank you so much, Prof. Thank you for that very extensive set of examples, practical examples as well. I want to turn my next question to Dr. Orie. And actually, this question, comes back to the communities because I really got the undertone of the passion you have for, preservation of communities. And it's that thin line between commercialization. Prof. Olushola Olujobi talked at length about the fact that the investors tend to be foreign, not all, but they tend to be foreign. And of course, they want their ROI. And they are working, mining, exploring what tend to be personal areas, settlement areas, cities, villages, rural areas. We don't really hear of mining happening in the urban areas. It's always in the rural areas. So the question I have for you now is, how do these energy transition disputes pit long-term community sustainability goals or against the long-term sustainability goals against the short-term commercial goals? How can we come up with innovative ways? How can we come up with innovative ADR mechanisms, strategies to manage these what needs to be, butting at the heads, the commercial interest versus the communities, so that even when these disputes arise, we keep the community interests paramount. You did mention that the long-term effects of places like Ogoni continue to echo. Ogoni took place 25 years ago, and I believe Dr. Agbakoba was one of the first legal counsel for, at the time, Ken Sarawiwa. And we're talking 30 years ago, and those devastating effects of that land remain. And like you said, the lands are destroyed, but the dispute's ongoing, and the dispute is not going to back the viability of the land. So now that we see that more minerals are being discovered, more fields are being explored, what can be done immediately, short term, to manage these very contradictory perspectives? The community and the need for sustainability, the need for ESG principles, and then on the other hand, the need to get that ROI, the short-term realization of profits. So I'll leave this to you. Thank you. Unmute yourself. Thank you.
Okay, thank you for the question. This takes us back to the issue of representation and legitimacy. You find a situation, as a background, you find a situation where where there is an issue, maybe the foreigners are coming in, the initial discussions, and you see a whole lot of people juggling around or jostling around as representatives of the community. But most times they are representing themselves and their pockets. So the community is not aware of what is happening, and just the few elitists, unquote, I'm using the word elitists very carefully, because sometimes it's not that they're elitists, but they just happen to be opportunists at that time. So they will corner the people and see how they will exploit the situation. And the document, at the end of the day, either the community are not even aware of what is happening, because sometimes in those remote areas, people are not as knowledgeable. People do not look out for issues that do not concern them. For instance, people may not even go to some have very large rivers. Some may not even go to the deep river. They may just go to the periphery, fetch water and go their way, or go for firewood without knowing that right deep into the forest, so many transactions are taking place, and they are not, that will affect them at the end of the day. So when these issues are happening, they are not aware, and the impacts sometimes are irreversible. What is going to happen in such situation? What should be done to balance such interests of the community and interests of the commercial interest, is that from the inception, there should be the stakeholder participation. The stakeholders, the locals, should be carried along in every discussion. The oil marketers, the oil companies coming in, the OICs, it's important for them to find out who are the true representatives of this community, the village heads, the family heads, because sometimes if you take only the village head collects and puts inside his pocket. The owners of the land are not aware, and the day they become aggrieved, they will take it. It becomes a different ball game, and they will not allow the OICs to come and prospect oil in that area, because the land is actually theirs. They don't want to know how much the chief has collected. So they must be carried along. They must be part of that initial discussion. If they are not, and it must be discussed in the language that they understand. It is not English. If they are not English-speaking community, such discussions must be done in their own native dialect. An interpreter must be procured that will explain to them, because some of these things are lost when you translate them to English. I was telling my ADR students that timing in Nigeria or in the whole of Africa, it's not wrong, but our concept is different from the Englishman. When they say it's African time, it is not that it's African time. It is just that our own orientation of time, concept of time, is different. In Africa, we have morning, afternoon, and evening. That's all. We don't have 8 a.m., 7 a.m., 12 a.m., 12 p.m., and 6 p.m. No. So they will ask you to come. Oh, when are we going to meet? When the cock crows, we'll meet at the town hall. When does the cock crow? It could be 4 o'clock. Your cock may crow at 4. Another person's own may crow at 5. Another person's own may crow at 6. But the bottom line is that they want this meeting to take place early. That's it. But the Englishman will come and say, oh, we fixed a 6 o'clock time and these villagers are not here. No, they have not failed. But because their own concept of time is different from that of the Englishman. So these things must be interpreted. This issue, the discussions must be explained and held in the language of the people, so that they will flow. They don't need anybody to tell them what was said at the meeting. Nobody should paraphrase for anybody. And so when there are stakeholders, it makes it easier. Also, part of the carrying along is that there should be class representative. It is not just the family head. Times have changed that everybody seems to be representing him or herself now. If the technology has made it possible for even the village woman to be able to answer call, so there's a limit to how much you can represent the person. There's a limit to how much you can speak for anybody. Everybody, there must be, like the gender, If it is a female, somebody must represent the female, because sometimes some of these things, when it comes to vulnerability, there is disaggregation in impact. It does not affect people the same way. Therefore, those who wear the shoes know how it pinches. They should be involved at this onset of discussion, at the early stage. What involves the way climate change issues, the way environmental degradation will impact the male. It's not the same way it will affect the female gender. Therefore, the female gender should have a seat at that discussion forum. Also, the children. So these are the things that will be reflected in, that will be incorporated in part of the early discussion. And then there should be transparency. It is not that some selected people after the meeting, some other people will go behind and have another discussion. No, there must be transparency, not just that there will be transparency. It must be seen to be transparent, because there's a different thing, a different ball game between being transparent and between being seen to be transparent. It must be abundantly clear that there's transparency being entrenched in that discussion and in application. And then what is said, there must be a will to implement what was discussed. It is not that the OICs will discuss, agree on one thing, and then they go back and begin to implement another thing. Because most times that is what happens. The stakeholders are not holding brief, are not representative of the class, of the grassroots. And so you find a situation where at the end of the meeting, another meeting is held to reinterpret what was discussed, to reevaluate what was discussed, and then what is being implemented is different from the original thing that was discussed. That is why at the end of the day, you find a situation where you find an all well abandoned midway, because the people are holding the people hostage. They are preventing them from coming to prospect in that place, because there has been a shift from what was already discussed. So this commercial interest must be balanced with the interest of the locals. It is not just about commercial, and then there should be social CRS, corporate social responsibility. You cannot just take their oil and leave the place. If they are seeing, some of the problem we have with Ogoni land started the time they visited Abuja. The youth came to Abuja, and then they saw like the electricity, they saw the flyovers, and they screamed. And that is it what is being used, our money is being used for, and we are wallowing in abject poverty, in the environmental degradation. We cannot use our farmland. And they said, no, oh my God, this can no longer happen. So there must be corporate social responsibility, so that these people, their life is also transformed, while this commercial aspect is also taken care of. While they're exploiting, they must ensure that they put in place corporate social responsibility, so that the locals will know that their life has also have been improved by the reason of the OIC, the oil companies being in that place. So they must give commercial interest a human face. They must preserve it. They must give it a human face. It is not just money, money, money. Also, they must ensure that the fundamental rights of these people are not infringed upon. It is very crucial. You must protect their fundamental rights while you are doing your commercial business, because these are rights that have been guaranteed by the Constitution. They are innate, and you cannot alienate them from, take it away from them. So that consciousness must be there. And at all times, they must be carried along in every development, in every commercial, and then they should, part of carrying them along is also to give them employment. You cannot be using their land, you cannot be exploiting oil, and they're looking for jobs. And a hungry man is an angry man. One day they will become upset and cancel or disassociate themselves with all that you have done in that place, and tell you that, oh, this is not it, this is not it. And in drawing up those agreements, the oil companies must be very, very careful. Everything that needed to be included, just like some of my colleagues, other participants have said, everything that needed to be included, every clause, arbitration clause, and must be not just included, but must be clearly and unambiguously crafted. Because some of the things that border on interpretation of the agreement, the documents may not be, you cannot perform, it may not be implemented because they are flawed with ambiguities. They are flawed with terms that you cannot explain. So it becomes difficult for you to say, oh, we agreed that we're A and they are now doing S. Those things must be, and that is why it comes back again to experts. Who is drafting this agreement? Is it just anybody? Who is explaining what to the locals? Is it just anybody? What is explaining? Does he understand it? So it's not just an ordinary interpreter. We come back to the situation where whoever is interpreting, whoever is explaining, must be one who has scientific knowledge of the environment, who has knowledge of him, who has environmental content as part of his knowledge. It's not just being a lawyer. He must be schooled in the nitty-gritty of environmental law and be entrenched in the environmental space to be able to handle such issues, because they are not as straightforward. They are usually very complex and complicated. That is part of the nature of environmental dispute. When they arise, they are not straightforward. The parties are usually many. The people that will be affected are usually so many. So whoever is interpreting, whoever is handling it must ensure that terms included in the document are very clear and unambiguous, and that the risks are brought to minimum. They must watch out for performance risk. Are there risks that are being included, or areas like lacunas that are being allowed in that document that will make it impossible for the document to be implementation to be impossible, or to be fully performed, or to increase the performance risk. Also, the issue, and watch out also for the ecosystem. What is it that is in that environment that affects these people? What do they have? Is it a stable environment? What are they doing? Assuming it's a fishing community and you are tampering with the space we are about to exploit, there will be vibration. Are there alternative means of livelihood that you are providing for that period? Because there will be diminution in the volume of fishes in that area. Once that vibration starts, the fishes will disappear. It will require you as an expert to know, environmental expert, to know that these are issues that must be taken care of. The villagers will go to the stream, they will not get fishes again. What has happened? The fishes are relocated because they also work with the waves. They work with the tidal waves. So once, excuse me, once there is a change in that current, it will affect the fishes. They will either die, those that will survive will migrate to another environment that is friendly. So you must put in place things that will take care of this operational and infrastructure risk. Not just sure that there is the noise at a manageable level that will not affect the fishes and affect the income of this way, because it's a chain reaction, sort of. Once one chain is broken, the link is broken, and it will affect a whole lot of other things. Thank you.
Thank you very much, Dr. Irma, for that very extensive and well-elaborated reasoning on actually stakeholder management. And it's something that every ADR process should factor, stakeholder management, and also how do we give back to the communities where we, as you said, exploit from. So we're calling it as it is, actually. They're exploiting for profit. And so in turn, how do we make sure and enforce that they give back to those communities that they're taking from? I'd like to turn my next question very quickly, though, to Mr. Ag. And I hope you wouldn't mind if from this point on we've been to time a little bit more, because we have a 2-hour allocation. But I think this is a very important question that if you could sum up for us in, say, about 2 minutes, and around truly, how can we in Nigeria and beyond Nigeria on the continent position our ADR institutions to become global hubs for energy-related ADR? Because something Professor Olujobi mentioned, right, this seminar was we are so rich in natural resources, whether it's bitumen, cobalt for mobile phones. We have a lot, and more fields are being discovered. Believe it or not, more and more fields are still being discovered. And if we, why should we not in turn be a hub for the very same energy-related disputes? It makes sense. There should be a correlation. So, Mr. Agada, just to summarize, what, in your opinion, as a chartered arbitrator, ADR professional, should the institutions be doing to make sure that we become the hubs so that we are not arbitrating our matters in foreign institutions? And that's not because we don't want to or we're being hostile, but because we also deserve to reap from where the minerals are. So we should be the hub. We should have a good base of experts, arbitrators, mediators, conciliators in this space. So I leave that question. If you could take it in just 2 minutes, then we will move on to the Q&A. Thank you for all your Q&A questions, but unfortunately we can only take 2, and then we can then have our closing remarks. Thank you, Mr. Agada. The floor is yours.
Thank you very much, ma'am. As a country that is working with different sources of renewable energy, we can position our legal systems as ADR institutions to become global hubs for energy-related applications. One, by strengthening regulatory framework, developing clear and predictable regulatory framework that support energy investment and transition. By ensuring transparency, accountability, and consistency in the contract signed with investors always kept between those executing it. There are content in it. I don't want people can avoid it. So it's very important. Some of these things have to be very, very transparent. It will resolve a lot of issues. And aligning to national laws with international standards, such as the unsocial model of, and then investing in local arbitration capacity. By using specialized arbitration institutions, investment protection and factors. Local arbitration to reduce costs, infrastructure, and ensure cultural and jurisdictional relevance. If you don't do that, the benefit of having the seat of arbitration will be taken by the jurisdiction or the
Are we muted? I can't hear.
Apologies, Mr. Agada, if your audio is not too good, do you want to just adjust? Thank you.
Okay. Can you hear me now?
Yes, I can.
Yes.
Thank you.
Thank you.
I don't know the connection. Hello?
Sorry.
Hello?
Yeah, you can.
Connection.
Still a little bit unclear.
Sorry.
You can turn off your video. Let's see if that improves the audio.
Okay, I'm trying to. Can you hear me now?
Yes, much better. Thank you.
Oh, okay. Okay, so I thought that the connection.
You can carry.
Hello?
I think. Yes.
Hello?
You can proceed. You can proceed.
I thought that the connection.
Yeah, the network, I think.
Okay. I talked about strengthening our regulatory framework Yes, I talked about strengthening our regulatory framework by developing clear and predictable regulatory framework that support energy investment and transition. I also talked about ensuring transparency, accountability, and consistency in decision making. Not today, the position is this way, tomorrow, the position is. If we are going to achieve consistency, there's no way we can make progress to harness the benefits of mining. Then we also need to align to national law with international standards. For instance,
The
there is
audio,
social law and social model
the
law.
audio
If you can
is
adopt it, there are lots of. Can you still hear me? You hear me well now?
I can hear you better now
Hello?
without, I can hear you
Okay.
better without, yes.
Okay. I'm still using one. Then I was using two get it. So I'm using one now. Possibly. Okay. So I talked about investing in local arbitration capacity by building specialized arbitration institutions with expertise in energy law, training of arbitrators, judges, and practitioners in energy law, investing in making investment in ESG factors, and then promoting local arbitration to reduce costs, foster trust, and ensure cultural and jurisprudential or jurisdictional relevance. You are hearing me? Can you hear me?
Yes, yes, I can. Thank you. I
Okay.
can. I can.
Yeah.
Thank you.
Thanks. So my right point for
Thank
the question
you.
you asked. Thank you very much.
Thank you. I appreciate you. Okay, I'm going to hand over to Emmanuel, my colleague, who's going to pick out just two questions from the Q&A box to treat. So we will direct those questions accordingly. So Emmanuel, I can hand over to you. Thank you.
Wow, what's a very exciting panel discussion thus far. It has really been so enlightening and very engaging. So I'll just quickly pick from the Q&A section some questions that have been shared, so the panelists can just answer those questions. I'll pick two questions from it. So the first question was dropped by Rani, and I don't know if it's an E or a Mrs., but the question reads thus. It said, in light of the ongoing omnibus process at the European Union level, particularly the proposed simplifications to the Corporate Sustainability Due Diligence Directive, CS3D, which risks fragmenting the civil liability regime across member states and influencing regulatory approaches in developing countries. To what extent can alternative dispute resolution, ADR mechanism, constitute effective remedy avenues for right holders? More specifically, in the context of renewable energy projects characterized by multi-layered obligations and complex value chains, are ADRO mechanism, when assessed against a first core critical criteria of effectiveness? Because I think in renewable energy sector, there are other layers of criteria regarding the specificity of sector, such as accessibility, impartiality, transparency, enforceability, and right compatibility, truly suitable to guarantee access to justice and effective redress for affected right holders. I think this particular question was directed to Prof when Prof was doing his presentation. So Prof, I don't know if you'll be able to address this question that was dropped by Ryan.
Yes, yes. Thank you so much. What a wonderful question. Another eye opener. Yes, ADR has been a mechanism for resolving disputes amicably among the warring parties, especially in the context of transition to low carbon source of energy, because that's where the world is going to now. Procedural flexibility of it is very key because ADR is flexible. It gives the parties the opportunity to shape the modus operandi of resolving their differences. Efficient technical fact-finding experts who are sound in the knowledge of law, whose award are legally sound and scientifically informed. ADR fill the gaps in all the legal frameworks, the lacunas, the legal framework left unfilled. ADR comes in to fill those gaps by ensuring amicable resolution of disputes. It's not about win-win-win or lose-lose. It's about amicable resolution. Let's resolve. Let's come together. Let's negotiate. Let's compromise. Let's move on. Let's sustain our business relationship. Let's protect the environment. Let's make profits. Let there be fairness. Let there be independence. Let there be impartiality. Let there be what? Consciousness. Let there be what? Conscious of environmental conservation and protection. ADR comes in. Resolve the difference between the party amicably. It has been seen as what? It's not even a necessity any longer. It is what? It's no longer an alternative, it's a necessity. It's sine qua non. It's sacrosanct in resolving differences in the energy and renewable sector. Renewable energy, as we all know, is an alternative to solve Nigerian epileptic power supply. We have it abundantly. We are blessed with it. What we need to do is to amend our existing law in conformity with what we don't have currently. We don't have any specific law, well-designed law on renewable energy in Nigeria as of today. Thank God for climate change. Thank God for several policies and regulations that we have. But there's a need for us, like other advanced climate, like Norway, UK, and US, and Australia have been doing, for us to have a specific tailored legal framework on renewable energy. The way we have climate change act dealing with climate change, the way we have mining law, Mineral and Mining Act 2007 dealing with mining, we need to have a specific legal framework, coherent laws on renewable energy. All what we have is just incoherent laws, our laws that are fragmented, scattered everywhere, that we are using on renewable energy. We need to have a specific tailored legal framework, specifically for renewable energy. So promote this necessity as a means of combating epileptic power supply in the country. So let us know there's a need for us to look inward to combat this incessant power outage in the country. Like other countries, we are blessed. We have the sources of renewable energy abundant in the country, but we're not using it. We're not tapping to it. Thank God for solar. People have started using it gradually. Even at Burkina, they have solar in their small kiosks to solve their epileptic power supply. Even they have solar panel, and that small kiosk in Lagos, in Abuja, you see them, there's a solar panel on top. But hence the need for us to reform our laws, to rejig our laws, to accommodate renewable energy resources. Thank God for the amendment of Electricity Act 2023 as amended 2025. Tinubu is doing well. He did some things. I'm not a politician, but these are two steps this man is taking. Total good reforms steps that he's taking. That if we accommodate it, it will take Nigeria to greater heights. Thank God for the amendment, which has decentralized energy. States now can set up their own energy commission. States now can amend their own law. States can generate their own laws now and send it to national grid and also use it for their own domain. Lagos State tried it, independent power sector, then during Tinubu era, but he failed. But thank God for the amendment of this the Constitution too, section 14, sub B, paragraph B, giving states decentralized electricity generation, giving states the autonomy to set up the electricity commission. Lagos State has done it. Kano has done it. Rivers has done it. Even Ekiti State has done it, and some other states are also working in progress to do it.
It's 1 o'clock.
Hence the need for us to amend our laws to give room for electricity generation, distribution, marketing, and regulation. Thank you.
Thank you very much, Prof, for that answer that was given and well-considered response with respect to the question. I don't know if Mr. Agada, if you want to make any comments with respect to the question that was equally asked from your end or from Dr. Erima, if there's any comment from you. Okay.
Yeah, thank you so much. I just want to quickly add that it is important in addition to what you have said to ensure that there is thorough due diligence in looking at the documentation and due diligence in ensuring that the host country is their laws are friendly. Because he is talking about international arbitration law, is in doing business, particularly an international investor, you need to be sure that you have a good understanding of the law of the host community, of the host country where you are going to invest in. Because that law may well not accept of some type of arbitration or some type of award. So you need to be conversant with that law. It is not after you have gotten an award, you begin to run helter-skelter concerning enforcement. From the onset, you need to be sure that the host country, their laws are friendly and that you're able to enforce, because there's a recent decision, I'm trying to remember the case, which negated the provisions of the New York Convention to say that, the New York Convention is about enforceability of foreign awards in different member states. But there is a recent decision which is to the effect that in doing that, it has to be interpreted in the context of the laws of that community, and that the laws of that community will take supremacy where it does not protect them in several areas. This is revolutionary. It's a 2024 law decision. I'm just trying to remember the court where that was decided, that decided it. But the bottom line is that in doing this business, due diligence must be emphasized. There is no apology for not being diligent. There is no apology for not doing what you're expected to do. So parties must ensure that apart from agreement, whatever they've agreed, they must be sure, they must be conversant with the law of the seat and the law of the place. They must be sure what the host country the host state can tolerate and what it cannot accept, and the implications of certain awards in those states. If I get that case before the end of this session, I may just drop it. I really cannot say why I can't remember it, but it is what it is right now. So
it's all right, Doctor. You can forward to us. We'll share with the participants once we get the case from you.
Okay, another thing I want to say is that there is now a new trend for use of judicial precedents, particularly when it comes to foreign decisions. So the parties must be conversant with what operates in that locality. There are some situations now, like the ISID. They allow, awards of ISID are published, but with consent of the parties. So it's not the case that no award cannot be published. But even now, some awards are beginning to be used partly as for judicial precedents. That is where parties have to just be conversant with that and take notice of it. Thank you.
Okay, thank you very much, Doctor, for that answer. Okay, the next question that I want to ask was asked by Blessing in the chat box. And she said, which factors are considered before a legal professional can be regarded as an expert for a specific area of law? And I would just want comment from each of the panelists with respect to this. Mr. Agbada, I would want to take your comment for a minute. Prof, equally your comments, then from Doctor.
Sorry, I didn't get that question. If you can just help.
I will just quickly read again the question. The question says that which factors are considered before a legal professional can be regarded as an expert for a specific area of law?
Okay,
Doctor, did you get the question?
Let me
Mr. Agbada, you can go on with your response.
Okay, let me chip in here. Like, as you are not an arbitrator, even though you are a lawyer, until you get inducted into the Chartered Institute of Arbitration, either any of them, and then you'll be trained specifically for those that area of law. So there are different institutes that you can train or under. For instance, even as an arbitrator, you might not be a specialist in the construction industry. There's an institute that handles arbitrators in the construction industry. There are institutes that handle arbitration in mining industries and several of these industries. So you just get information about these industries, get their requirements, and get enrolled with them. That makes you an expert in that area, not just being a lawyer. Thank you.
So thank you, Mr. Agbada. I don't know if any other person wants to make a comment before we go to the last question.
Thank you. For you to be an expert, you must have been certified by an accredited Chartered Institute of Arbitrations, either in UK or in Nigeria. And you must have sat on several landmark cases, milestone cases that have been a precedent. And two, you must have cultivated disciplinary skills with acumen in technological, environmental, commercial awareness, and you must specialize in that particular area, maybe in energy, mining, renewable energy, transition. You must have done a lot. You must have technological knowledge. You must be proficient in climate or sustainability issues if you focus in energy or mining. And you must have international knowledge of international legal framework. And you must be abreast of information needed in that particular field. And you must also be up to date. You must be globally visible. If you are not visible, people will not know you. Even when you are sitting on several arbitral panel. But if you are not known, you are not known. You must be globally visible. People can be able to, with a push of button, with a press of button, they will be able to see your profile online, so that they'll be able to know what you have, the transaction you have dealt with, what you have done, area you have sat on, what you have done, and everything. We will give people better picture of you. As it's also expected of you too to sharpen your knowledge, because you need to be abreast of information. So there's a new trend every day. You need to read even more degrees, more matters, reading every day to be abreast of information and study law reports, especially on ADR, because ADR is confidential. But you need to be abreast of it, like Lagos Institute of Chartered Arbitrator, Lagos Home, or UK, or Lagos Multi Court, which you have to go there. You see a lot of matters. If you have an engagement with them, you read from there, you'll be able to know what is trendy and what you need to know. Thank you.
So thank you very much for that answer, Prof. So if a person is still online and you're listening, so one of the considered things for you to be an expert, even though you're a lawyer, is that you need to get the specific certifications, get inducted, get those international expositions, sit on some of these matters, and ensure that you have specialized knowledge. So your general knowledge is not just sufficient when it comes to ADR. You must have specialized knowledge. So I want to quickly ask one of the questions that was asked in the chat box by Nora. Nora stated that given the continued investments in fossil fuels, even as we talked about a just transition, how do you think this contradiction is shaping energy disputes today? And can ADR really help balance those competing interests? That's our question. So I will take the question again. So in case you didn't hear me when I earlier said it or took the question, so I will just repeat myself with respect to that question. It states that given the continued investments in fossil fuels, even as we talk about a just transition, how do you think this contradiction is shaping energy disputes today? And can ADR really help balance those competing interests?
Okay, can I look at it?
Yes, Prof, you can.
Thank you so much. ADR is the way to go. It's the point of call. It's a necessity because it is flexible. It helps the party to resolve their differences amicably, particularly on the issue of joint management, profit sharing, development, environmental protection. It is a multi-party multi-issues capacity that can be resolved amicably. It's based on experts. Because in litigation, you may not even have the experts. The judge may not even be knowledgeable on climate change, sustainability development. But in ADR, among the panel, you have experts. You have experts in energy economics, environmental protection, science, engineering, construction, because the composition is always robust, which always ensure that the decisions are legally sound and scientifically robust. And ADR is very fast. There's fast track, and it brings about efficiency, and there's cost efficiency too. Relatively, it is cheap, and it is customarily and legally acceptable by the people because it has been on from the time immemorial. It has been a modus operandi our age father are using to resolve their differences. And besides, it prevents hostility, it prevents bad blood. It ensures there's amicable resolution of differences, no matter how the difference is between the warring parties. And besides, it gives room for war for the party to control the proceeding, unlike litigation, where everything will be done by the war, by procedure, by the court, like lawyers. You only sit down, your lawyer will be the one doing the business. But in ADR, you are involved. You bring out your claims, another party brings his claims, and they will look for areas where you can work, reconcile, where you can have a consensus idea with them, because the aim is to promote win-win. Thank you.
Thank you very much, Prof, for that. Maybe I'll just hand over to Beverly. So there's one last question for Prof on the chat box, and I feel it will be needed that answer is given to that question. Beverly, maybe you just ask Prof the question. It's a question from Gabriel with specific reference to Prof.
Go on, go on, please.
Please go on. Please go on.
Okay, let me just read out the question. So Gabriel said that in view of Professor Olushola Olujobi's very erudite presentation, especially his standing on the platform of utilizing local content law and enjoining us to always look inward in ADR matters, said, I am therefore completely befuddled by his omission of NICAB or similar national arbitration institutions from his listing of international and national institutional framework for arbitration. I am befuddled by his submission in this regard because I am one who published an article in NICAB Journal of Arbitration some time ago on the discriminatory provisions of the ADR regime of the 2020 Nigeria Gas Transportation Network Code, which solely nominated SIAB UK Nigeria branch for arbitration adjudication in gas transportation network contract. I'm more at sea because our revered former president of NICAB is Chief Afe Babalola, the chancellor of the university where Prof is also a respected teacher. I'm a legal practitioner and my name is Gabriel, and I would like some clarification from that. Prof, I don't know, maybe you just want to clarify that.
That question, I'm not even able to get that question properly, but be that as me, ADR is the way to go. The legal framework are there. The legal framework don't perfect law anywhere in the world. All laws are work in progress. Hence the need for a reform of that law to be able to combat current trends, current social society. No law is perfect anywhere. Even UK, US, Norway, their laws are work in progress. They amend their laws.
Prof, let me just give a direction.
Let me just add to that. Maybe I don't know if Prof heard him very well. I think the challenge he has is that you listed some legal regime, the legal regime for ADR.
Yes,
and you did
that's it.
The institutional framework, not the legal regime. The institutional framework, and that you didn't include NICAB, which is the Nigerian Institute for Chartered Arbitrators, of which I'm a fellow anyway. He has no fears. I do not think that Prof exhausted the legal framework. And I don't think that was the intention of Prof. I believe he was just highlighting them because there are several others. I'm also a member of the Nigerian Maritime Arbitrators Association. So, which Prof also didn't mention. So I take it that he just gave us some examples because there are several others. There's a construction institution, arbitration institution that he also didn't mention. So there are quite a few others. The Nigerian Institute of Chartered Arbitrators is a recognized arbitration institution. So you do not have any fears. The journal is ongoing, it's published, I think it's biannually. I also have copies I've contributed. And indeed, I'm the chairperson of NICAP for Abuja branch. So you can understand why I'm taking it upon myself to make that clarification. Thank you.
Thank you very much, Doctor, for that clarification. I felt it was needed for us to give an answer to that. Thank you. So I'll hand over back to my co-moderator, Beverly.
Thank you very much. And Dr. Mauri, thank you so much for actually stepping in, because I think as a proviso, important to remind the audience that it is quite a pressured thing to be a panelist, and you're not always going to recall single institute or case, or so an omission is certainly not should not be taken in a negative light. Sometimes these things happen. You can't possibly recall everything said here is obviously said in good faith and without any. So I just thought I would mention that. But I definitely, spent a good length of time discussing so many critical issues that are cropping up in the energy shift that we are witnessing as Nigerians, Africans, in this very critical space. And certainly I know that I've come away a lot richer, very enriched in my knowledge and at least basic understanding of some of the key challenges. I just want to use this opportunity to say a very, very big thank you to our esteemed panelists. So Olushola Olujobi, your presentation was marvelous. It was enriching, very, very invigorating. For those of us who didn't even have a passion for environmental law, suddenly our interest has been piqued. Dr. Rima Orie, your compassion, your empathy definitely shines through with your expertise. That, like you said, these are people behind every dispute. There are real people, real communities that have to be managed. It's not just about money on the table. It's about how do we get the best possible outcomes for the parties involved. Mr. Agada, thank you very much for sharing your insights as a chartered arbitrator. Certainly, the point was made about how parties can manage a dispute practically, paying attention to the contract drafting stage. For those of us who, and I'm sure many of us in the audience do draft contracts, dispute management begins from the point of drafting. And Mr. Agada rightly reminded us to take care when drafting and make sure we're using the right clauses, we are using the right venues, we're using the right seats, because these all have implications on resources, whether that's financial or non-financial. And Dr. Orie also gave us very magnanimously some examples of free resources that we can all begin to look into and take courses on. And she herself says that she is a facilitator, an adjunct at some of these places. There is a need for some of us to step up to the occasion, whether that's by learning more, whether that's by sharing your knowledge, and becoming a facilitator, because we need the knowledge. We do need the knowledge in order to empower ourselves as ADR professionals. So on that note, I really do want to say a very, very big thank you to Dr. Orie, Professor Olujobi, Mr. Agada, the people that referred you. It was not an easy task. Believe you me, even trying to find the right people to come and educate us. So it's a reminder that we all need to continue to make ourselves available, continue to share knowledge, information, put out programs, so that this industry, the ADR industry, can grow alongside the commercial growth of the energy and renewable sector. So on that note, behalf of OAL, a thank you to all of you. We will stay in touch. This is the beginning of what I hope will be a fruitful relationship where knowledge sharing is concerned, and so on and so forth. Thank you, Emmanuel, my co-moderator. Thank you so much for your contributions as well. everyone in the audience. Without you, there's no session. Your presence today, you came out in numbers. You came out in numbers, which tells us that we're on the right track. And hopefully we will run more of these programs. So please follow us on our handles, our LinkedIn. Dr. Orie and Professor Olujobi and Mr. Gada, we will get their handles and share if they are open to that, and we can share their details also with yourself so that you can follow their updates on LinkedIn. So without anything more, thank you very much. There's a question I do have from Jason Akban, and he's, I hope the beautiful slides will be made available. We will have to ask Professor Olujobi, and if
It's
he
accessible.
says yes.
Yes,
Oh,
yeah,
beautiful.
for the whole world.
Thank you so much. Thank you very much. So we will be sharing that as part of the recordings with everyone that took time to participate and watch. Thank you very much, and enjoy the rest of your day. And let's all continue to be advocates for cleaner energy and more effective disputes in this queue. Thank you very much. Thank you so much.